We're live.
Okay, thanks. Well, welcome back to Senate Education, Tuesday, January 18th, 2:48 p.m. Still on S219, legislation that is looking at public dollars going to religious institutions and whether or not we can put some barriers, guidelines, restrictions, etc. around them. We have with us David Hall from Ledge Council. Mr. Hall, thanks for joining us. My question was this, and I'll let Jim Desmarais and others perhaps jump in who have other questions, or if I'm not clear on mine. The reason we wanted to talk about a public taking is one of the proposals that I believe we will hear later this week or early next week from folks is whether or not you can make, let's just say, let's leave it in the business world, a company, a private company, and turn it into a public company. In other words, for example, if you have a bus company, if it's a private company, and all of a sudden the state of Vermont were to take a step and move it into a company that would be recognized as public then therefore run by the government, in that way. Public company. And so that's the question. So as it relates to this world, in the education world, there is a proposal out there that's being talked about that if we were to really stop, one way to stop any public funds from going to religious institutions would be to stop all public funds from going to any independent schools. And that, of course, would shut off the spigot to a lot of schools. One might also say to our 4 historic academies, which I know you're familiar with. But under the new proposal, it would say that we would basically, the legislature would change these schools from private schools and classify them as public schools. So that's where the public taking language comes in. Some of us have said that if we were to go forward with that kind of thing, there would be some concern in the business community also just around, and there would be legal issues, making a change from something that's public to private. And so I don't know if there's anything you can add to this conversation, or just even let us know as it relates to the business community, that kind of transfer, that kind of legislative action. We're digging into it. We need to know more, and we thought we would ask you about it.
Sure. Okay. David Hall, Legislative Council. Good to see you all virtually again. So I hear the issue. I see that. It's wow. What a neat. You guys are doing all the cool stuff in here. You got the establishment versus the free speech. You got takings.
Yeah.
And
it's a cool committee, but that's been established.
Jealous, If I knew that you were going to be doing all this stuff, I wouldn't have let them hire Beth. I would have taken over. This is a constitutional issue, and sure, you could apply it to a business or a school or all kinds of different things. It's so in that respect, I mean, I am an attorney and I do have some familiarity with the subject, but there's a lot of nuance. I'll give you the basic framework. Takings, the power of eminent domain is, it's been around for a very, very long time, long before our country was a country and our government was a government. And it was one of the things that our Constitution was designed to defend against, was just sort of, taking private things and using them for the public. And the consequence of that is that in the federal Constitution, and that is both applicable to the US government, it is also applicable to the states because it's incorporated in the Bill of Rights and it's applied through the 14th Amendment, is that a taking has to have 2 components. There has to be a public purpose and there has to be just compensation. And if you can't demonstrate both of those things, it's per se unconstitutional. The tension in the evolution of the case law over time in our country has really focused on 2 different types of takings. There's a physical taking where like the bus company, you take their property, you take the buses, you take the business name and goodwill, you take their building and their payroll and whatever else. And that is a physical occupation. And that is a physical taking that requires a public purpose and just compensation. And then it's gone far beyond physical takings to regulatory takings, to issues. It comes up in environmental law, it comes up in labor law, it comes up in other places where essentially the argument goes, as a consequence of a regulatory scheme or some sort of mandated action or inaction by the government, you have essentially eliminated the value. Through regulation, you have taken the some or all of the value of private property. And in a case of, if you demonstrate a regulatory taking, that also requires a demonstration of a public purpose and just compensation. But those are the two big components of it. And so if you were looking at a bus company or you were looking at a school and you wanted to take the Greyhound bus service in Vermont and convert it to the Green Mountain Transit service in Vermont, that's a pretty demonstrable public purpose. And as long as you pay them the fair value, then legally you have the right to do it. It's a question of public policy. It's really the limiting factor. Should you do it? Is that how you should exercise this very substantial government authority? And I imagine that analysis is the same with the schools. If you wanted to say there's only one school, it's independent, it's private, that serves this whole area, we need it in order to bring it into the envelope, make sure it's meeting all our requirements, serving the populace in this area of the state. Could the state exercise its eminent domain authority, take that school? If it can demonstrate a public purpose and it pays for the taking, then arguably you do have that authority. The questions then become thorny too. What is the value? What is appropriate? What is just compensation for that taking under the Constitution? How much? What terms? And then also, obviously, you do have the burden of demonstrating that this is for public good. So, for instance, you can't just. There have been cases where the government uses or transfers its eminent domain authority for one private business to take other private property and do private development. So, for instance, in the utility context, our utilities have the right to take property to put in transmission lines, distribution lines. One of the more recent cases was out of Connecticut, where a mall developer was able to condemn other property and repurpose that property for a private use, but because the court found they could demonstrate a public benefit and that there was just compensation, they allowed, private property to be taken for a quasi-public private purpose. So for a school, it seems to me like the public good, the public benefit, public use component, not that high of a ladder, and then you just have to pay for it. Again, the threat.
Yeah.
It may be the bigger question of can you is should you, right? That's the public policy debate.
Right. Right. And what sort of, precedent would we be setting? Yeah, I think serving a public purpose, who generally defines that? So, for example, if we were to switch our 4 historic academies from private schools to public, is that just a case that's made before the legislature, basically? Hey, and that's really it. In other words, it's been argued by a group of public schools or whomever that we would make this change.
Well, so, machinery would be required to accomplish it on the front end. So you would presumably authorize, let's say, the Agency of Education I mean, you would direct it in statute to exercise the state's eminent domain authority to take private property and dedicate it to this public purpose, and you would appropriate money to provide compensation. I'm sure those conversations would have to happen on the front end if you wanted to try to do it amicably. But you know, if the bus company didn't like it and you passed the bill and gave the money and did it anyway, then the bus company's recourse is to sue the state to enjoin the exercise, stop the exercise of public domain, eminent domain, and to bring that case to court. And, you know, the state would have to prove its case to the court then that it does have indeed a public purpose and that it has provided just compensation. Does that answer your question?
Yeah. So just to recap for those who might be with us for the first time in this conversation, I do think this committee is going to be asked that, or the case is going to try to be made that sending public dollars to religious institutions is such a threat that we indeed should make these kinds of changes that we're outlining. In other words, to say, as we know, the only way to stop all public dollars from going to religious institutions is stopping any kind of funds going to any independent schools. So you have, as we know, a number of different independent schools throughout the state where students are tuitioned to those schools. And you could have a small school in Orange or wherever it might be, that this would stop that from happening. The one thing that I think people are interested in that might be putting this proposal forward is protecting our historic academies. And the only way to protect them, if students, again, can no longer go to any independent schools, with public dollars, and they could only go to public schools, would be to make those independent schools public. And so I think we'll hear from those academies that are not interested in that. I think we'll hear a little bit. We've heard from Mill Moore that also has some concerns. We've talked about this a little bit as a committee in terms of what kind of disruption that would likely cause throughout the state. But it's just something that I think this case is going to be made to us. And so that's why we really just want to dig in, David, and understand really what, the ramifications are, how a public taking generally happens, the frequency or lack of frequency that these kinds of things transpire. So
Sure.
What you're saying is I think helpful.
Yeah, I mean, it happens with some frequency. I mean, think about any of the water lines or transmission lines or gas lines that have been put into the state in the past 20 or 30 years. That was literally an action of the state going landowner to landowner and saying, we need an easement to put this line through your property. We can pay you up front and you can agree to it. And if not, we're going to take it and we're going to pay you what we think is fair. And if you have a problem with that, you're going to have to go to the Public Service Board and see if you can challenge it. But
yeah,
that's how it works.
Can you think of a business that's happened to, where the state has taken a private business in the past 50 years or so, or whenever, and said, in the interest of the public good, we would like to, we're going to now make this business public?
Off the top of my head, I couldn't offer any specifics.
Yeah.
Like I mentioned that Connecticut case. I mean, that's just one that springs to mind, but I'm sure there are dozens of examples, and I'm more than happy to dig in and just bring you back some examples of how this is manifested.
I'm looking at Jim. It looks like Jim, did you want to add something to that?
Not that question, no.
Okay. Any questions for Mr. Hall at this point related to a public taking? And okay, Mr. Desmarais. David, just hold, if you can just stick around for a little bit. Go ahead, Jim.
While we have David here, we were talking about the your bill and some issues with the language on the Vermont Public Accommodations Act. Can we look at that together with David?
Please,
because that's his
please.
topic, that's his area. So if I could just get screen share again and put up the bill, I can show you.
Okay.
This is change of topic. Okay. So here's your, we'll go through this in a minute. This is your committee amendment to 219. And you will recall that we had a section on the VPAA amending this. Yeah, here it is, section 3. And we weren't sure why this is here. So this amends 9 VSA 4502, which is the public accommodations law. And 1 is all about giving religious organizations kind of a pass, if you will, to be able to refuse to provide services for marriage ceremonies if they disagree with the nature of the ceremony. And then we have this language in 2, which was added last session, about that the section will not be construed to permit religious schools to deny services, etc., to individuals because of their membership in one or more of the specific categories, including sexual orientation and gender identity. I didn't know this was necessary. It just seemed like it was, you recall that it's not harmful, but it's not, in my view, necessary. But I wanted to get David's view because David, this is David's area, if you will.
Mr. Chair, would you like me to?
Yes, please. Thank you.
Sure. Yeah, thank you, Jim. I'm not sure where the language came from. I mean, this is a little bit, when I was joking about how you get to work on the cool issues, but this is one of them. And I'm sure you're all at this point familiar with this tension between the right of association under the First Amendment, and then also, which flows from the right of free speech, and then, but then also the free exercise and establishment clause issues under the religious components of the amendment as well, and that's where this tension lies, is the extent to which we can force or require, as a condition of receiving funds, that a school not discriminate against particular classes of persons. That's what these state public accommodations laws do, is they say, is a function of our police power, we are prohibiting discrimination on the basis of these characteristics. And that's a fundamental power of the states, the police power, and that is only limited by the Constitution of the United States. Well, it is the Constitution of the United States that says that religious organizations or private organizations, that are truly private, not open to the public, have a right of free association and don't have to admit into their membership or hang out with or anything else, people with whom they disagree. And so that's the conflict we have between First Amendment and then also states' police powers with respect to these Public Accommodations Act. So I understand that tension, and I understand that there may be an argument somebody wants to make that, we want our Public Accommodations Act to apply to these schools in all situations. And we don't want any sort of exemption to the Public Accommodation Act requirements. And this provision is saying you can't use the loophole, the exception for religious services, and somehow transmogrify that into the ability to discriminate in your provision of education services. I don't understand that leap. just as a matter of drafting, of statute, of organization, I don't know how anybody would read the religious and marital services exemption from the VPAA and somehow shoehorn that into, a pass in the context of public education. Those things don't line up to me. The way this is put together doesn't line up to me. And I think Jim's right, 99% harmless, but I think confusing. And I would recommend that you not include it. And that if you, wanted to be more direct about the VPAA's applicability to public education and public funds for education, then there's a more direct way to do that than putting it here in this subsection, which relates specifically to, marriage services and privileges.
Right. Yeah, no, I would, if I may, would agree with that. I mean, it's clunky. It doesn't feel right. So what are you proposing, that we remove? I mean, why is the marriage piece then, does that need to stay there?
I couldn't make the argument for its inclusion. I don't know.
Yeah. Jim?
I think it should go.
Yeah.
I think that section 3 should go.
But, and keep the direct anti-discrimination language in.
Well, this is the VPAA. I mean, there's a section there, as we talked about, that
Yeah,
gives some leeway in terms of marriage ceremonies. That's in the law today. I'm not saying
Forget
to
it, right.
change that. That's
we're not
already
looking to play
there.
with that. Yeah,
And so the new language that was added last session,
yeah.
we don't need that section. We don't need to amend that. So there's no reason to have that section at all.
So you would still have just for clarification, I just don't have it right in front of me anymore. So the language that Senator Perschlick proposed that we changed, that's still there. You're just getting rid of the marriage piece of that.
Nope. I am saying, yeah, I am saying this whole section 3 should come out of your bill. There's no,
This is language for Senator Hardy.
oh, sorry, this is wrong. Do you see what I have on my screen now?
Yeah, still language for Senator Hardy.
Oh, really? Except sure.
Sure.
Sorry.
It's on the website. You could open it that way.
No, I don't want that one. I want here. Sorry, wrong document. Is that the right one? Can you see that?
Yeah.
Okay. So what I'm saying is we just delete section 3 altogether from your bill. Because you're not changing what's in 1 up here, which has to do with marriage. And what we added in 2 is unnecessary and confusing. Is that clear?
Senator Perschlick.
Yeah, it would keep section 4, which was what you just said, Senator Campion, about the
Right.
link we talked about yesterday, Friday.
On Friday. Yeah, I just wanted to make sure that that was still there.
Yeah, and I can't remember why we added 2 or if that was just something else, but I guess, well, yeah, we'll leave it at that.
Okay. No, it's a bit of a clunky process, going from one session to the next, first year to the second. And yeah, as long as what was proposed, and it looks like it's still there, that language from Senator Perschlick on Friday, that's the important piece. And that's in section 4.
Do we want to ask Mr. Hall about that, or? No,
David?
he might have too much excitement for one day. If he's
Right.
I'm not familiar with the piece that you're talking about right now. Jim, which one's that?
Jim, do you want to explain it to him?
Sorry, I was doing something else for a minute. What was the conversation?
So section 4, the language that Senator Perchlik proposed that we edit on Friday. We're asking David to weigh in on that.
This is unlawful employment practice. This is Damien's area. And this is a result of his testimony last week.
Yeah,
I'd leave that one to Damien.
okay, fair enough. Okay, any other questions for Mr. Hall before we have a walkthrough of the new draft? Jim, any final questions?
Not for me, no.
Okay. Mr. Hall, thanks for being with us. Really appreciate it.
Glad to join you anytime.
Yeah, very helpful. And if you don't mind, it would be great just to get a sense of public takings in the state over the past, 25 years.
Sure, I'll have a look.
Yeah, thanks. Okay, so committee, we have a new draft. Is the new draft up on our website, Jim?
It is.
Okay. All
Should I
right.
take
so
you through
let's
it?
Look,
Okay.
1.1.
let me just get there. All right. So this is a new draft, draft 1.1 of S219.
It's yeah, so this is a committee strike-all bill,
Yep.
right? So you're amending what you submitted as introduced, and your committee is now amending it as a strike-all. No changes in section 1 from the underlying bill. In section 2, we did make a change. We had an exemption here, which under the previous draft or as introduced draft, create an exemption if you were in compliance with Vermont's employment law that Damien talked about, right? That exemption is gone based on our conversation last time. And that underlying law is gone. So Damien agreed that this would be good, okay to strike. So this section 4 now strikes that provision under Title 21, which allows that employment discrimination. So that's now gone. So now all you have for the ability of a religious school in terms of employment discrimination is the ministerial exemption under the Guadalupe. So that's the only thing that now exists as a part of US constitutional law. We have no further provisions under Vermont law that will allow employment discrimination by these schools. Okay. And then dual enrollment is as it was, so no changes here. And I think that's it. So it sounds like on the next draft we'll change dual enrollment a bit. And I will delete section 3. And that's what will be.
Okay. Committee questions. Feels like it's getting tighter. We still have to hear again from a number of folks, but Senator Perchlik.
Thank you. Thinking out loud, which I know is dangerous. Is there any issue with the early college as it is different from dual enrollment slightly? Or do we have to mention that at all?
No, I mean, early college has never come up as an issue here.
It doesn't matter where the student that goes to early college, it's the same thing, right? They apply to AOE, AOE decides if they're eligible, then pays the tuition for that.
I'll have to go look at that. So first I can get back to you to be sure, but it's never come up in this conversation before. But let me just check that statute to be sure.
But doesn't the money, money doesn't go to the institution. It goes to the college. I think it's the pathway of the money. I think that's right. Trying to remember.
You mean Senator Lyons? So it goes directly, also goes directly to the college.
To the college.
Or it goes directly to the college.
I think it goes to the college. I don't
Okay.
think the student handles it or anything.
Right.
I wondered if the
But I
same,
don't, but that, I would wait for Jim's
Yeah,
word on
yeah.
that.
No, I'm glad Senator Persler raised it. Senator Persler.
yeah, I'm pretty sure it does go to the college. I think Senator Lyons is right on that, but I wondered if the same issues come up. I think we,
Yep.
like if they go to St. Mike's,
Yep.
religious school, does that matter?
Yeah, it's an eligibility question. I mean, the money goes to the college just for dual enrollment too. So the question really is about the eligibility of the student. So let me check that out and get back to you.
Okay. Anything else for Jim on this topic before we shift for a moment before our next witness comes in? Okay, Jim, I'm going to ask you, and I haven't raised this with the committee, and we'll see where colleagues stand, but I did receive a call from, or had a conversation with the Community College of Vermont. I think we'd have to hear from VSAC on this also. I'm wondering if you would look at some language that would allow refugees, I guess, refugees and or asylum seekers into the state. Is there a way? So let me put it this way. We know as refugees are coming in to the state, I'm wondering if there can be an exemption in terms of the residency requirement before they pay in-state tuition is really what I'm wondering if this committee would entertain or not. But I thought we could get some language, and Jim, if you would reach out, I would say probably if, or I can have her come in contact with you either through this committee, and that's Joyce Judy at CCV. But we do know that we have refugees in the state, more refugees coming, asylum seekers, and is there something that this committee would entertain around, again, an exemption for how long you have to be in the state before you qualify for in-state tuition? Is that clear, Jim?
It is. Is this just for the state colleges and UVM, or?
I was thinking, honestly, largely CCV, but because that was the way that the request came to me. But why don't we start with CCV, honestly, and then we can go from there. Senator Hooker.
What's the requirement now, Senator Campion?
I believe it's a year.
Is it a year?
I think it is a year. Yeah. So this was raised, again, I had a conversation with Joyce Judy about it. And is there, as we think about this state being a state that would welcome refugees and asylum seekers, is this something that we can do for folks? I mean, I'm open to making other shifts as well. Honestly, I hate to see somebody sit around for a year, for God's sakes, and not take a class because, they can't swing it. This might be a larger conversation, but maybe we start here and I'll have Daphne, are you there? We'll have Joyce, Judy, and VSAC come in and talk to us a little bit about it. Okay, so I'll work with Daphne to find a time. There was something, and I would anticipate if we were to take this step, we would put it into a miscellaneous education bill that has other items that we've sort of touched on a little bit that would go into such a document probably in the next couple of weeks, making this shift. Okay. So tomorrow, well, we're going to hear from literacy folks in about 10 minutes, literacy report, and I want to continue the conversation on dyslexia when they're here. But tomorrow I've asked, we know that Mark Levine and Secretary French are coming in to talk to us about the rollout, COVID policies in schools. I've also asked Secretary French and Heather Boucher to come in to talk to us about the governor's priorities that he outlined in today's budget. Historic, generally we try to have the administration and if it is going to be connected at all to our policy in this committee, come in and talk with us about some of those policies. So I've asked them to do that tomorrow. So we have another discussion that'll probably go about an hour, actually about a half hour, since there's a chairs meeting still at 4. And that witness be here at 3:30. So why don't we take one more quick break and come back at 3:30.